Well, hi, everyone. Thank you very much for joining us for another of our Zoom sessions on various immigration matters. I appreciate that you're joining us during your lunch hour today and hope that your day is going well. If you're in Michigan and other parts of the Midwest, it's over 90 degrees today. So I hope everyone is able to stay cool during this very hot weather. So again, welcome and thank you for joining us. My name is Mike Sherman. I'm with Sherman Immigration, and we specialize in various types of immigration, temporary work visas, family-related visas, and a special focus on healthcare and business-related visas and green cards. Today, we're going to be talking about employment-based J1 waivers. And it's a very important topic, especially if you are a person holding a J1, or perhaps your spouse is, or perhaps you're part of the administration of a residency program and some of your residents and fellows hold J1s. So today we're going to talk about what can be done in order to deal with the infamous 2-year foreign residence rule, otherwise known as Section 212E. And as you all know, that's the requirement that a person holding a J1 who's in the U.S. for graduate medical education must first return home for 2 years before being able to change to an H-1B or to obtain any type of green card. Before we move ahead, I would like to say some thank yous. First of all, I'd like to say a huge thank you to Carolyn Taylor, my legal assistant, who does phenomenal work getting us ready for these monthly presentations. So thank you very much, Carolyn, who's sitting over here. Appreciate all your work. I'd also like to thank Jeff Bumbales for his technical assistance, and then also my son, Eric Sherman. Actually, I can now call him Dr. Eric Sherman for his technical assistance and also insight and help in reviewing the presentation. So without further ado, let's get started with J1 waivers. A little history, actually, before we really get into this. Traditionally, there was no such thing as a J1 waiver. People who came to the U.S. for years and years, who came here for a graduate medical education, were automatically subject to this 2-year rule, and there was no way to waive it. So traditionally, they really did have to go back to their home country for 2 years, and then if they wanted to come back, they would have to try and make arrangements with the U.S. employer to come back. First, either as an H-1B worker or perhaps instead of an H-1B on a green card, because back then the employment-based green card process did not take nearly as long as it does today. Back then, it actually was possible to get a green card within a reasonable amount of time and then to enter the U.S. with a job and with the green card and ready to go the minute that the 2 years was over. So with that being said, let's take a look at the first slide. So what is 212E? Well, that's actually the section of the law that contains this requirement that we are focusing on today. There are many different types of J1s, and J1 physicians, that's just one type. J1s, believe it or not, can be anything from camp counselors to au pairs to certain experts, but we're really focusing on the physicians because they're the only ones who are automatically subject to this 2-year requirement. Certain other people, certain research scholars and others, depending on their field of specialty and the country they come from, may or may not be subject to this requirement too. However, it's much easier for them to obtain a waiver of that requirement than it is for physicians. So for physicians to receive a waiver based on employment, it normally requires finding a job, a qualifying job that will qualify for one of the different types or one of the of J1 waiver programs. So normally this includes working in a medical shortage area of the United States for a period of 3 years for a U.S. employer, or instead perhaps working for one of the Veterans Administration hospitals that are located in every state. The VA system does not require that the location be in a shortage area, just that you'll be working for the VA at their hospital. Now, in terms of this type of waiver, and as it says at the bottom of this first slide, when we talk about medical shortage areas, these are areas designated by the U.S. Department of Health and Human Services officially as having a lack of physicians or not sufficient number of physicians to meet the needs of the local residents. So the areas of greatest need are what's known as HPSA, or Health Professional Shortage Area. Just below that are the MUP and MUA, which are medically underserved populations and medically underserved areas. And then also, as I mentioned a second ago, the VA facilities. So these designations are very important. And it's when a person is starting their job search, it's important that they keep this in mind, that not every area of the United States or of any specific state that they want to live in will actually qualify for one of these waivers. Now, thankfully, it is possible to punch in a location to the government's website to determine whether a specific work location is HPSA, MUP, MUA. And if you Google HPSA find by location, you'll be able to type in that information, and then the current status of being designated or not designated will show up on your screen. Now, to take a step back for just a second, what we're going to be talking about today in terms of J1 waiver options really applies to everybody, including Canadian citizens. However, there are certain other options that Canadian citizens are eligible for. But really, one caveat about this: what we're talking about are people who were Canadian citizens and then entered the US for graduate medical education. So on their DS 2019, for country of last permanent residence, it does list Canada. Now, on the flip side of that are people who, let's say, come to the US as a J1 from other countries, and in the meantime, they gain approval of Canadian citizenship while they're here. So the problem is that those folks are still considered to be, for J1 purposes, citizens of the home country where they came from, where they got their certificate of need from, and not Canadian citizens, even though they now hold that citizenship. So these options that we'll be talking about here for just a couple of minutes only apply to people who are Canadian citizens when they entered the US and have Canada listed as their country of last permanent residence on their DS 2019 forms. So number one, first, in terms of the 2-year requirement, they can fulfill it by receiving a J1 waiver. And again, we'll be providing more details about the various waivers in just a couple of minutes. Another way to deal with it is to return to Canada and live there while commuting to a US job every day. Now, that works if the person wants to live in a border area, such as Windsor, Ontario, which is just across the tunnel or bridge from where we currently are here in Metro Detroit. And a couple notes: it is possible to live in Canada and then commute daily to the job using an H-1B visa. So you're really doing two things at one time. You're fulfilling the 2-year requirement by living in Canada and sleeping there every night, and also in the meantime, able to work in the US for a US employer as an H-1B worker. Now, when I say sleep in Canada every night, that's absolutely true, because there are records at the border in terms of when you cross, when you left, etc. So it's not possible to try and perhaps stay in the US all week and only go back on weekends, because ultimately the burden of proof is on you that you did cross literally every day into the US for work and then left every evening at the end of your shift and went back to Canada. So that's kind of a neat way. I don't like to call it a glitch. It's just something that the law, when it was drafted, that the people drafting it really just didn't think about these border areas where Canadians could literally commute back and forth each day. The last way of dealing with it for Canadian citizens is by deferring it. What they can do is they are eligible to get an H-1B work visa. They can't actually change status to H-1B in the US, but they can get an H-1B by having an employer obtain an H-1B approval for them. And then they simply go into Canada, maybe have lunch, maybe visit, whatever, drive back into the US and present their H-1B approval notice. So even though they don't have a J1 waiver approval, the law does allow them to enter the US as an H-1B worker and to live here. However, as it says in big font, this does not fulfill the requirement of the 2 years back home. It merely defers it. It puts it off. A person can have an H-1B for 3 years and then is eligible for another 3 years. But at some point in the future, we'll have to deal with that 2-year rule if they want to get a green card or stay in the US. So it's a temporary way to defer it if there is no other option and the person really wants to work in the US, and then over time figure out exactly what they want to do, the strategy that they want to employ for dealing with this 2-year requirement. Employment-based waiver options, and that's what we're here to talk about today. There are a plethora of different options. Back in the day when I was a young lawyer in the early 90s, there were really just two. So this is a little history lesson before we get into the various types of waivers. The first waiver type was through the U.S. Department of Agriculture, and that was for people who would go work in underserved areas, agricultural areas of the U.S., farm areas where there was very inadequate access, differing levels, but inadequate access just the same to medical care in these various areas of the country. Again, these were all federally designated areas, and the U.S. Department of Labor had no limit to the number of waivers they would approve, as long as someone was going to work for 3 years in one of these areas. The other old type of waiver that came a little bit later and then disappeared rather quickly was the old HUD waiver, which is the old U.S. Department of Housing and Urban Development waiver. And that went hand in hand with the U.S. Department of Agriculture, because the HUD waivers covered inner city areas, areas in the middle of cities that had inadequate access to physicians, and really the same idea. By working there for 3 years, you would get a waiver, you would fulfill the waiver requirement, and then you would be all done. And in the meantime, providing much needed medical care to underserved populations. Now, those two programs are history. And so let's talk about what has replaced them. The main one that you probably have all heard of is the State Conrad 30, named after the old Senator Kent Conrad from North Dakota, who was a huge proponent of allowing J1 physicians to work off their 2-year commitment by working in underserved areas of the United States. North Dakota is a very rural state. I can tell you from experience, because I've had many clients there, that there are many areas that are medically underserved, and that's why he started this program. Now, over the decades, it has been renewed over and over. There have been efforts to try and expand it, let's say from 30 to 40 or from 30 to 50, but those efforts have really not gone anywhere. And instead, what happens is Congress just renews it and renews it as it is. Now, what is this program? Well, this program allows each U.S. state to support up to 30 physicians for J1 waivers per year. Now, the interesting thing is that although it's a federal program and there are certain requirements, each state is actually free to set many of their own parameters in terms of what types of areas qualify, what are the requirements, what can be in a contract, what can't be in a contract, what type of supporting documents they'll require with a J1 waiver. For instance, will they require some evidence that the U.S. employer tried to recruit U.S. physicians, or will they just assume that there is no U.S. physician for that position? It's a shortage area, and so why require an employer to recruit when it probably will not turn up anybody? Some states are more user-friendly than others in terms of paperwork burden, data burden, etc. So these are great programs, but of course the downside, as you can see, is they are limited to 30 per year. Many states, especially New York, California, Michigan, Illinois, Ohio, and many others, receive well over 30 applications a year. Many years ago, many of the states had a first come, first served policy. So if your application was one of the first 30 that was received, automatically you were one of the 30 that the state supported. Over time, each state individually stopped doing that. They stopped having people race to the front door, literally, to be the first among the first 30. And instead, they used some type of algorithm or parameters internally to determine which ones they want to select. Generally speaking, for all the programs, there is an emphasis on primary care and other areas where a physician will be of the greatest service and help meet the greatest need. In terms of application process, application cost, and other details, these all differ state by state. Thankfully, the states all have websites that provide this information, and it's a good idea to pay close attention. Some have filing fees and some don't. Next is the HHS waiver, and this has become a very popular waiver. It's through the U.S. Department of Health and Human Services. Now, the nice thing about HHS waivers is that they're not limited to any number whatsoever. Now, they will only support J1 waivers where the physician will work in an underserved area that has a HPSA score of at least 7. And so these are areas of incredible need, extensive need for physicians, and primary care only. We'll get more into the details, but the nice thing is that there is no limit. It's not like the state programs where they're limited to 30. With HHS, the waiver process is standardized because it is a federal program. Everything is filed directly with HHS in Washington, and then they process the waivers. Next, we'll turn to the VA waivers for just a minute. The VA system, or Veterans Administration System, includes clinics and hospitals throughout the United States whose core focus is caring for U.S. veterans, active duty, retired, and others and their families. And these facilities are often in great need of more physicians, and so they are able to sponsor their own J1 waivers. Each hospital handles it on their own. They may have some communications with a central office, but generally speaking, they do it on their own. There's no need for an immigration lawyer to be involved. And also, they don't have to be in a shortage area. The fact that it's a Veterans Administration facility that certifies that they are short of physicians and they need your help, if you're the applicant, that is sufficient. There are some other things they have to do, but it does not have to be in a shortage area. Other waivers include the ARC waiver, NBRC, and SCRC. And these are specific waivers to specific geographic areas of the US. So these are for HPSA, or health professional shortage areas. The ARC waiver is in parts of Maine, part of the United States, including Maine, New Hampshire, New York, and Vermont. The NBRC is in areas of Appalachia that are so designated. And the SCRC is the southeastern United States, and they have specifications on their website in terms of what specific areas will qualify for that type of waiver. So let's talk a little bit more about the Conrad 30. So they really do have certain things in common, even though each state is able to set their own rules, their own requirements in terms of the documents that they require. First of all, you have to agree to work full-time as an H-1B worker in an HPSA, MUA, or MUP for 3 years in that state and actually in that location. Now, what do we mean by full-time? All of these programs require at least 40 hours a week. That's the standard. And in terms of full-time in one of those areas, what they mean is full-time providing direct patient care. What they don't mean is 40 hours including on-call time, time spent doing this or that, time spent doing paperwork, administration, that sort of thing. They really want at least 40 hours of direct patient care. If you end up working 50 hours and you're doing some other things during those other 10 hours, such as administrative stuff, making rounds, etc., that's not a problem. But the contract has to say 40 hours a week. Priority in all these programs is given to people who will be working in the most severe shortage areas and to primary care physicians. Now, for specialists such as endocrinologists, stroke physicians, and others, these programs also require additional evidence and data in terms of the availability or non-availability of specialists in your field in the specific area that you're seeking to work in. So there is definitely data required for primary care, but it is much, much less than is normally required for specialists. Some of the waiver programs require actually quite a bit of data, numbers of patients, exact number of practitioners in your specialty within a certain mile radius, whether it's 10 miles or 20 miles, and sometimes even information, names of the practices, addresses of the practices, how many physicians are in that practice. Again, depends on the state. And again, as we mentioned a minute ago, only 30 per year can be supported by each state. It's really important to note that one of the differences between the programs is that many of them have different time windows for the application process. For instance, some say that you can apply only in September and October of each year. Others say, well, we'll accept applications until we get 30 or more than 30, and then we're going to cut it off. So if you're thinking about a waiver program in a specific state, it's very important that you check the website of that state's Conrad 30 program to see exactly when you would need to get that application in. Preparing the application is something that an immigration lawyer really should handle, or the employer, if they've done it before. Maybe they can try it without an immigration lawyer, but ultimately most Conrad 30 applications are filed by immigration lawyers because it is complicated. There are a lot of laws and regulations that have to be followed. And so the reason I say that is it does take time to prepare a Conrad 30 application. It's not something that you can just fill out a one-page questionnaire, attach a diploma to it, and then send it in. It's much, much more detailed, and depending on the state, it can actually get really, really detailed in terms of number of providers and number of patients within specific geographic areas, and on and on and on. So some states require primary care physicians to work in a facility with a HPSA score of 7. And again, that's an area of great need or higher, 7 or higher. Other states are okay if it's an MUA or MUP or a HPSA. And in fact, it's interesting, some locations or some areas carry multiple designations. It can be a HPSA and an MUA, or HPSA and MUP. But HPSA is the area of greatest need, and that's what you would definitely want to focus on. Lastly, on this slide, some states do require a filing fee. Others don't. There is a lot of work that the states have to do in processing these applications, especially the ones that are very extensive, very, very well laden with data and statistics and supporting documents. So for instance, I've seen filing fees Illinois traditionally has been $3,000. Others, such as the state of Michigan, there is no filing fee. There is a filing fee for all waivers, which is a Department of State filing fee of $120. But the filing fee we're talking about specifically for Conrad here is whether the state charges its own fee to accept and process the application. Years ago, none of the states charged a fee, but over time, more have adopted a fee as a way to meet their costs in processing all of these applications. HHS waivers. So again, this is through the U.S. Department of Health and Human Services in Washington. As with the other waivers, you have to agree to work full-time. This must be in an area with a HPSA score of at least 7. If you are looking at a job and it's in an area with a HPSA score of 5 or 4 or 6, unfortunately, an HHS waiver is absolutely not available. That score of 7 is a hard cutoff, and that's it. They will not accept, they will not look at an application. The other thing that's important to note is that even if it has a score of 7 or 10 or what have you, if that location has been marked for possible withdrawal, or what they call proposed for withdrawal, HHS will not accept an application. So what does proposed for withdrawal mean? Periodically, HHS will look at various areas around the United States to determine whether there is still a shortage of physicians in that area. And if so, what is the shortage level or need? Is it still the 7 or the 10 that it was scored some years ago? Or based on new information, is it an area perhaps that now has a sufficient number of physicians? In other words, a number of J1 waivers have been granted maybe, or physicians have moved into the area to the extent that there are now sufficient number of physicians. In that case, the government marks it as an area that is being proposed for withdrawal. HHS has a very, very firm policy. They will not, under any circumstances, accept a J1 waiver, even if the HPSA score is 7 or higher, if the area has been formally marked for withdrawal by the U.S. Department of Health and Human Services. Now, with that being said, there are some state Conrad 30 programs that may accept such areas. It really is a state decision by each individual state and their Conrad 30 program. For HHS, you have to practice in primary care, and that's defined as what we've listed here, which is family medicine, general internal medicine, general pediatrics, or OB-GYN, or general psychiatry. Now, another caveat, very important note, is in addition to it requiring primary care, you must have completed your primary care or psychiatry residency no more than 12 months before the contract start date. So HHS waivers are great, but it is something that you would want to apply for during your last year of training, preferably early on, so that you meet this requirement and that you go right from your training program right into your new J1 waiver job. The other thing that's really important to note is that if you have any type of specialty training, such as fellowship training, they will not accept a waiver application from you. Now, that's true even if you say, well, look, my underlying residency was in internal medicine, and although I have a cardiology fellowship, I am willing to work for 3 years full-time as an internal medicine in order to get a waiver and fulfill it. And after that, I will then go and practice cardiology. They won't accept it. I don't know if it's just that they're being a doubting Thomas. They don't actually believe that a person like that would actually set aside their cardiology training that they worked so hard for a period of 3 years and do just general internal medicine. Perhaps they're worried that some cardiology work would get into the mix of work. But no matter what, it's something that they don't allow. Now, as mentioned earlier, the good thing with HHS waivers is that there's no limit on how many can be granted. HHS can grant as many waivers as they want, and you can apply for it at any time throughout the year. There's no specific time window at all. But of course, the earlier the better, meaning during your last year of training, because there are a number of approvals that have to take place. One is HHS has to look at it and decide that they want to approve it or recommend it. Then the U.S. Department of State has to review it, and they will take time to then make a recommendation to immigration. And ultimately, it's the Immigration Service that will grant this waiver and really all these other types that we're looking at as well. So it's a multi-step process just to get through the J1 waiver part of all this. And then after that is the H-1B process, which is totally separate. So as you can see, it does take some time not only to put the waiver application together, but also to go through the required government steps to get it ultimately approved so that you can then go ahead with the H-1B process. So it's Again, while you can apply at any time, the earlier the better, but that doesn't mean that you would apply during your second year, for instance, your PGY 2 year. It's really something you do during your final year of training. Moving on to the VA, I know we discussed this a little bit at length earlier, but just to kind of recap, you have to work for 3 years at a VA medical facility. It does not need to be in any type of medical shortage area. Just the fact that the VA itself is saying we have a shortage of physicians in your type of specialty, whether it's internal medicine or psychiatry or cardiology or whatever, that's all that's required. The VA facility has to show that there are no U.S. physicians who are qualified and able to work at the facility by doing national and local advertising. It's really up to them to do that advertising. They handle the entire process from start to finish. It's been my experience that when they really want a physician, it's because they need that physician, and their efforts to recruit a U.S. physician have been totally unsuccessful. And so this recruitment is not something to worry about. It's usually something that they've had ongoing already anyway. So it's not something special that they do in addition to what they normally have been doing. It is something that is an ongoing practice and procedure over there. Now, again, they handle the entire process. So the nice thing is from A to Z with the J1 waiver process, they handle everything. You don't need an immigration lawyer. There's really nothing that you as a J1 would need to do. They also normally handle the H-1B. I'm not sure if this is still true, but years ago, they would sometimes, depending on the facility, allow an outside immigration lawyer like me to handle the H-1B process. It's been several years since I've done one. I don't know if they still allow it or whether perhaps they have some type of internal legal staff or human resources who also handle the H-1B process. So those are VA waivers, and where it says apply at any time, absolutely, those are available at any time. There's no time limit, and you would basically have to get in touch with individual VA facilities to see if it's something that they could sponsor, and then they would work with you from there. Now, let's talk about these other types. There are lots of letters here. It almost looks like the alphabet. I guess maybe I could call it the alphabet of J1 waivers. So it's the ACE, the ARC program, or ARC, SCRC, NBRC, and DRA waivers. Really what they have in common is that they are great programs, but they're all location specific. So you might be in an area and that might come within the purview of the Delta Regional Authority or DRA, or you might be in another area and that's an NBRC area. You might be in an area that could qualify, let's say, for an ARC waiver, ARC, and also perhaps a Conrad 30 waiver. Some states have a policy, which is that they will not consider you for a Conrad 30 waiver if you qualify for one of these other types of waivers. States are trying to reserve the 30 spots for situations, I mean, at least many of the states are, where the person absolutely has no other way to get a J1 waiver. And so the state in that case would be willing to assign one of its coveted 30 spots to that physician. So just to kind of go over this quickly, the Appalachian Regional Commission, or ARC's areas, include counties in 13 different states, including Ohio, Georgia, and Maryland, and some others. The Southern Crescent Regional Commission, or SCRC areas, are counties in 8 states, including Florida, South Carolina, and Alabama. And then the Delta Regional Authority, it's kind of getting tongue-tied here. They include counties in 8 states, including Arkansas, Illinois, and Missouri. So generally speaking, I mean, these areas, like with most waivers, they've got to be in a designated shortage area like HPSA, mental health HPSA, MUA or MUP. Certain waivers or certain programs require it to be HPSA, while others will accept any of the above. So each of these programs has a website. And in addition, if you're thinking about a specific state, probably the best place to look would be to start with the state's Conrad 30 waiver website to see if there's anything on that website that says something like, if you're going to work in one of these counties, we require that you seek an ARC waiver. We will not entertain an application for instance, a West Virginia J1 waiver or a Florida J1 waiver, where these 30 spots are very coveted. We will only support people for these 30 positions if there's absolutely no other way to get a waiver. So you can't get an ARC waiver, you can't get an HHS waiver, nothing else will work. Then we will consider you for one of these 30 spots. Things to keep in mind. And these are very important things to keep in mind. Your employer is required to pay the costs of the J1 waiver and the H-1B. Now, years and years ago, the H-1B was always required to be paid for by the employer. However, there really was no enforcement of that. I would say until around 2009, that's when enforcement really started. So prior to that time, the rules did require that the employer pay, but there was no enforcement. And very often, the physicians might find themselves in a position of perhaps having to pay. The costs were actually a lot less back then also. Honestly, the cost of an H-1B, well, the filing fee anyway for an H-1B back when I started was $125 or $135 if you needed a consulate to be notified. Now, as you all know, H-1B expenses are out of sight. The filing fees are exorbitant, and premium processing, and many H-1Bs have to be filed via premium. That filing fee alone, just the premium filing fee, is $2,805. So you can imagine we're talking about many thousands here. But all of the waiver programs require that the employer pay the cost of the waiver process. That includes the lawyer if there is one, anything else that's involved, and the same with the H-1B. It is actually illegal, against the law, for an employer to say, look, we'll pay the costs, but you have to reimburse us. That's not legal. They have to pay the costs. It's a cost of doing business. It's a cost of them obtaining the physician services, and they've got to pay. Next, while fulfilling the waiver, you as the beneficiary, the physician, can start the green card process, whether it is employment-based or marriage-based, but you cannot complete it until you've completed the 3-year work commitment. So let's say you're going to, your employer is willing to do the standard green card process for employment, which starts with a step called PERM or PERM, and then move on to the next step, which is called I-140, before moving on to the third step, which is called I-485. So because of your being in the 3 years of H-1B status while you're working off your J1 waiver, you can do the PERM process, the I-140 process, and then it has to stop. So even if your priority date is current, meaning that if it would not be for this J1 waiver, you could immediately jump into the final step, which is the I-485. You can't do it. You've got to wait until the 3 years are over, and then you can finalize the green card process. Of course, for those folks who were born in certain countries where there's a huge backlog, and specifically India, also Mexico, China, and the Philippines, even once you complete the 3 years of your J1 waiver work, you will not be able to immediately jump into an I-485 due to the huge backlog in the category, the EB2 category for people born in your country. So, but still, there are huge benefits to getting the first couple steps in the green card process done. In addition to everything else, number one, it puts you in the queue, and number two, allows you to go beyond the usual 6-year H-1B limit, so that you can get additional H-1B time as needed until the green card is ultimately approved. Now, there are other types of green card processes that you can do. If you look at some of the presentations we've made in the past, we cover those, but one of the others is the Physician National Interest Waiver. That's based on your agreement as a physician to work in a shortage area for a period of 5 years, in return for which the government will allow you to skip the PERM, Alien Labor Certification process. That's the first step in the usual process, and go right to the I-140 step. But it does require a commitment to work for 5 years. Now, the good thing is that, it really wouldn't apply in the J1 context, but for, let's say, your friends or colleagues who are not J1, who have done residencies in shortage areas as an H-1B, they can actually count those 3 years as part of the 5 years. But for people who did their residency and fellowship as a J1, even though the programs may have been in shortage areas, they cannot be counted as part of the 5-year requirement for this PNIW type green card. Now, lastly, it's really important to think about the possibility that it could be necessary at some point during the 3 years of employment, as you're fulfilling this J1 waiver that you've worked so hard to obtain, that it may be necessary to change employers or change work locations. Now, this doesn't happen very often, but it is important to keep this in mind just in case, unfortunately, something happens. For instance, let's say an employer has brought you on board, and there really aren't enough patients in this location. And for business reasons, the employer has decided that 2 or 3 months from now, they're going to be winding down the work at this clinic and closing it. Or somehow Maybe it's not a shortage of patients, but for some other reason, the clinic needs to close, or perhaps, unfortunately so, but once in a great while, we hear of situations where employers are not honoring the terms of their contract. In other words, they have a contract with you as a J1 physician, a J1 waiver. You're now working for them as an H1B. Your contract says you're supposed to work a certain number of hours at a certain location or 2 locations or what have you, and you're supposed to be paid a certain amount of money. Well, unfortunately, once in a great while, there's an employer who can't or doesn't want to abide by the terms of the contract and says, okay, I'm not going to pay you X, I'm going to pay you 80% of X. Or I know I'm supposed to employ you 40 hours at this location, but there simply isn't enough work. So I'm going to have you work here for 30 hours a week, and then I'm going to stick you at this other clinic, not in a shortage area, for the other 10 hours. So all of this, as you can imagine, creates turmoil and havoc. And so it's really important that you look at your waiver program, whichever one you're in, and just take a glance at what their policies and procedures are for if in horrible circumstances, there comes a time when you may need to consider making a change. The J1 waiver programs really are all reasonable. They understand that there may be circumstances beyond your control where you've done nothing wrong, you've done everything you were supposed to do, yet it is not going to be possible to fulfill the full 3 years of that J1 waiver that you got with that employer and at that work location. Most waiver programs are fine as long as you document what the problem is, and they're agreeable to allowing you to consider to continue the J1 waiver as long as you find a new job in another shortage area, or maybe even the same shortage area, just a different employer. Now, for those people who are seeking to change states, in other words, hypothetically, let's say you got a J1 waiver to work in Illinois through the Illinois 30 waiver program, and you have found a waiver job, in a shortage location, but it's in the state of Maryland. It really would be up to the folks at the Illinois J1 waiver office to decide, are they going to let you go? Are they going to be okay with you moving to Maryland to help patients there and not fulfill your full term of taking care of patients in Illinois? That is really something that they determine on a case-by-case basis. I would say it's much easier to stay in the same state, whether it's the same shortage area or a different shortage area, because it's easy for the states to sign off on that. And anytime there's a change in employers, 100% of the time, there has to also be a new H-1B filing. So that new employer must file its own H-1B. Number one, it transfers your H-1B to that new employer. And number two, that's the official way of advising the Immigration Service of this change to the terms and conditions of the original J-1 waiver that you received. So with that package, or in that package, not only would be the traditional H-1B documents, but also information about the change, why you're making the change, and evidence that the new area or the new location is in fact in a shortage area. Immigration typically signs off on these, and they do so by approving the H-1B. So they never issue a notice or a letter or any kind of document saying something like, we have reviewed your proposed change, we have no problem with it, is fine, etc. Instead, they simply issue an H-1B approval notice, and that's the green light to you and to the new employer that they have reviewed the terms and conditions of the changes that you're proposing and that they are acceptable, and they are allowing you to continue with your waiver. If they had an issue, they would undoubtedly issue what's called an RFE, or request for evidence, and that would be their way of issuing a detailed notice saying whatever issues or problems they have, or what types of additional evidence they might want to support the request, and then ultimately, hopefully approve the request. So which waiver is best for you? Well, we've discussed a lot today about the different types of waivers. And so in terms of which waiver is best for you, I mean, some of the factors will lead you the right way, such as what state do you want to work in? What part of the state? What type of, what is your, are you internal medicine? Are you a specialist already? Let's say you're finishing up a cardiology residency. Where is the facility located? Is it an HPSA area, MUA, MUP, mental health shortage area? That sort of thing. So it will lead you in the right direction. The other thing is that many physicians work with recruiters, large physician recruiters who have a lot of experience placing physicians into various shortage areas. And so they can sometimes tell you, look, last year we placed 3 internal medicine physicians into this one area of Georgia. This is an SCRC area. And so we're very familiar with these waivers. Our immigration lawyer will handle it. It's no problem. These waivers have been approved with no problem. And so yours should be approved with no problem as well. So usually it's not the situation where you have like 5 or 6 different waivers that you can choose from, and then you have to determine or try to determine, okay, which is the best for me. It's usually very, very clear, very straightforward, based on what the state will allow and what these various agencies will allow, and also, of course, what HHS will allow in terms of which waiver you use. In addition, I mean, if prior physicians, let's say some of your seniors from last year have been placed in that area with that employer, they can give you information about the waiver process, which one was used, whether it went smoothly, whether there were any glitches along the way. So really, I mean, when in doubt, consult an immigration lawyer. I always like to say that, and it's true. Definitely check websites as well. All these programs have websites, but it's important also to speak with someone who does this day in and day out and knows the practical aspect of things, whether applications will work or won't, how fast or how slow they will go. Is this going to go smoothly, or are there expected bumps along the road that may not be reflected on the websites? But from a practical standpoint, as an immigration lawyer who has handled these before, it's something that we know is going to be coming up, and we can try to proactively deal with it to try and make the process go as smoothly as possible. Now, if you use a recruiter, or if you just deal directly with a physician or medical practice, many of them have their own immigration lawyers. And by that, I mean they have an immigration law firm that they regularly use. And so you would definitely want to, as this J1 physician, thinking about accepting a job with this entity, talk to that immigration lawyer, find out what the waiver process is going to look like, find out what the H-1B process is going to look like, and the green card process as well. It's your opportunity to speak with the immigration lawyer who will be doing the groundwork on your behalf to get you what you need, which is a J1 waiver, H-1B, and hopefully a green card as well. The only caveat I would say is that, if an employer tells you that they would prefer that you not speak with the immigration lawyer, or they won't let you speak with the immigration lawyer, really be very careful with that employer, because if they won't talk to you now, or they won't let you talk to the immigration lawyer, what's going to happen when you have questions in the future about temporary trips outside the US, getting an H-1B visa stamp, visas for dependents, things like that? It's really critically important that you have an open line of communication with this immigration lawyer, because immigration lawyers are unusual. It's the only kind of lawyer that I'm aware of, really, that can do 2 things at one time, which is to represent both parties to a transaction. So with J1 waivers and H-1Bs, the lawyer is actually representing both the employer and also the beneficiary, you as the physician. Every other type of law that I am aware of in the United States, you can only represent one side, one party, the plaintiff or the defendant, the applicant or a facility, etc. So immigration law is a little unusual, and that's why it's critically important that you have an open line of communication with the immigration lawyer, whoever it is, or their staff. And again, if there's any problem with that, then I would tell you, really consider a different job, because there will be a time, undoubtedly, when you really need to get an answer from the immigration lawyer, and you really need it fast. And what you won't want to do is run into a brick wall and not get an answer, and then have to try and either figure out what to do on your own, or maybe contact a different immigration lawyer on your own and try and get an answer out of them. They may or may not be willing to help you. They may or may not be able to help you, because they don't have all the information about your situation that the other immigration law firm has, the one that's handling the work for you. So in conclusion, hopefully this has been helpful. This is meant not really to be a comprehensive look at all of the different types of waivers, but really more to give you an introduction to the waivers. And again, whether you're an administrator in a residency program that has J1 physicians, residents and fellows, or whether you are a physician yourself, my hope is that this gives you some background, a knowledge level, a comfort level to know this is the world of J1 waivers, and these are the questions you should be asking. These are the things you should be looking out for. These are the possible bumps in the road. Not a comprehensive view of every program, of course, but things that are in common and some things that are different, and really the necessity of doing your homework, and then speaking with a lawyer who regularly works on these things, who can answer your questions and give you not only a time frame for when things will happen, but also a measure of comfort, a comfort level, knowing that you're in good hands and that this will be taken care of promptly and properly. And that way you can focus on your patients, knowing that in the background, all this legal stuff is going on and will be taken care of. So with that being said, as always, thank you very much for joining us. I really appreciate the fact that you're spending your lunch with us. Hopefully you had a good lunch and maybe a cup of coffee to go along with it, or maybe cold coffee here in Michigan or the rest of the Midwest. But if you have any questions, I'd be happy to answer them either now, or if you feel like emailing me or calling, that would be great too. Our contact information, which is right over here, is always the same. So feel free to email me at mike@shermanimmigration.com. Calling is good too. Here is our website. The nice thing about the website is that it does have copies of all the videos that we've done so far, and I'll keep adding them every month so that there's a whole library of videos that will hopefully continue to be helpful to you, or that you can refer to if you have specific questions, such as what is a physician national interest waiver green card, or other questions, what is an H-1B visa, etc. And just backing up for a quick second, next session will be next month, July 18th, also on a Thursday, and it will be job search advice for residents and fellows. I felt like now that we're starting the new academic year, people who are now in their last year, whether it's PGY 3 or 4 or whatever it is, depending on your field and your specialty, this is a great time, if you haven't started already, to find a job and to start the J1 waiver process if that's what you plan on doing. Certain states will start accepting applications early in the fall. And again, because it takes a while to prepare them, to get everything ready, this would be a great time to get those things started, or at least to find a position and start all of the necessary background work. So thank you very much again for joining us. Hope to see you in July. It may even be a little cooler. It's in the 90s now. I guess we'll wait and see. But I do appreciate you spending the time, and do feel free to reach out to me. I'm always happy to hear from everybody and answer any questions that you have. So with that, thank you again. Have a wonderful rest of the week, and hope to see you on July 18th. So take care and have a good afternoon. Bye-bye.